Under California law, money earned by one spouse during marriage is generally classified as community property, meaning that it belongs to both spouses. In Barbara Baragry, we explore the proper classification of money earned by a spouse while a couple is separated but not yet divorced. After marrying in 1956, Richard and Barbara Baragry lived together for almost 15 years and had 2 daughters. On August 4, 1971, after an argument, Richard moved out of the family home. He temporarily lived on his boat and then moved into an apartment with his girlfriend. But for 4 years after moving out, Richard continued to list the family home as his official address, ate dinner there most days, and had Barbara do his laundry. He also participated in family outings, even taking his family on vacations, one of which was with Barbara alone. And he continued to file joint tax returns, paid all the household and family expenses, and took Barbara with him to social and work events. Although Richard and Barbara didn't engage in sexual relations after he moved out, and Barbara knew that Richard was living with his girlfriend, Barbara hoped for reconciliation. Richard never negated that as a possibility. But on October 14, 1975, Richard filed for divorce. The parties disputed the date of their separation. Richard argued that it was the date he moved out, and his earnings after that date were therefore separate property belonging to him alone. But Barbara argued it was the date Richard filed for divorce, meaning that money Richard earned up to that date was presumed to be community property divisible in the divorce. The trial court entered an interlocutory or interim judgment setting the date of separation as August 4, 1971, the date Richard moved out. Barbara appealed to the California Court of Appeal.